Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're basically discussing Thai immigration, as we do a lot on this channel. And one question I get a lot from clients or prospective clients or just people contacting us with questions is, what's the legal basis upon which Thai immigration can deny my entry to the country? Well, I'll tell you. The Immigration Act, the Thai Immigration Act of BE Buddhist Era 2522, which is 1979 on the Western calendar, Section 16. Now, I'm translating and rather paraphrasing this section, so those who are watching this should not take this as the sort of end-all be-all when it comes to the letter of the law or how it will be enforced or how it will be interpreted. This is simply here for informational purposes only, to provide sort of a conceptual idea of how the immigration laws operate here in Thailand. But under Section 16 of the Act, in instances where, for reasons of national welfare or safety, culture, public peace and order, morality, or welfare, or when a minister considers it improper to allow any alien or any group of aliens to enter the kingdom, the minister shall have the power to exclude said alien or aliens from entry to the kingdom. So let's be clear on what this is. In an American legal context, the sort of public health and safety grounds they're kind of a fallback position. They're always there when you're dealing with things like immigration, customs enforcement, various aspects of like health-related regulatory agencies. That's always the fallback position. They have certain discretion associated with public welfare, public safety. The Immigration Act is no different. It empowers the minister, and he can thereby deputize those underneath him, the Minister of the Interior, and thereby deputize those underneath him, for example, the immigration police, to exclude people from the kingdom in their sole discretion. And within their sole discretion, they're basically saying, look, we feel that this person could be a danger to public health, morality, and culture. Very difficult to have any hard and fast rule with respect to that. I really liken this concept to a notion under American law. There's a doctrine called the doctrine of consular absolutism, or the doctrine of consular non-reviewability. And under those contexts, basically an immigration officer, or I should say a State Department official, a consular officer adjudicating a visa application, their factual findings are not subject to review. Very similar to immigration officers, very similar to U.S. Customs and Border Protection officers, Thai immigration officials have the ability to basically say, look, I sized the individual up when they were requesting admission through the port of entry. I felt that they were not, in my discretion, I felt that they, posed some sort of problem. They posed some sort of risk to public health and safety, and I excluded them and denied their admission to the kingdom. They can do this notwithstanding issuance of a prior visa. This exists. This is really, in my opinion, the bedrock section upon which immigration's discretion lays, if you will. They have their discretion, and it is derived from this section of the Act. So in the future, those who are interested in knowing the legal reasons for this, they need only look at the Immigration Act in Thailand and see where this stems from, and understand that Thai immigration officers can basically deny pretty much anybody that's not a Thai national entry to the kingdom for grounds that they deem, again, it's within the framework of this statute, but their factual findings are really not subject to review.